The next matter before the court is State of Ohio versus Charles Haslage.
Morning, members.
Good morning. Apparently, the state has waived oral argument, and so you will have 15 minutes to present
Thank you.
your argument.
I don't believe I need to reserve any time for everyone.
No, I don't think so, although, believe it or not, some have asked, so.
Very good. May it please the court, my name is Chris Caffarel. I am here on behalf of the defendant, Charles Haslage, who is also the appellant. The issue before the court today is whether the trial court had the authority to revoke Mr. Haslage's probation. The courts are clear that a person cannot pay restitution, fines, or other monetary penalties imposed by the trial court within the time of probation, as long as he has made good faith effort. They cannot sentence him to jail. What happened in this case is Mr. Haslage is a business owner. He owned several businesses. These businesses encountered financial difficulty beginning in about 2004, filed bankruptcy in 2005. Between 2003 and 2008, Mr. Haslage's businesses acquired a number of debts with the city of Lorain, the state of Ohio, and other civil judgments. These amounts were in excess of $3 million total dollars, including a civil judgment in the amount of $2.5 million. As a result of these unpaid taxes, the city of Lorain in 2010 brought charges against Mr. Haslage for not paying of taxes. They were misdemeanors to the first degree. Mr. Haslage pled no contest to these charges and was sentenced to jail, which jail time was suspended, and he was placed on monitored time. The lowest level of probation to check in to make sure that he was paying his restitution as was ordered. Initially, he was ordered to pay two large lump sum payments. He was not able to do that. Before the reporting time for jail, he had filed a motion for additional time to bail. Mr. Haslage, in November of 2010, worked out a deal with the city of Lorain, the Treasurer's Department, where he would be able to make weekly payments in the amount of about $400. Over the next approximately 5 years, the trial court monitored to make sure that these payments were being made and that he was complying with the terms of his agreement. Between July 2012 and February 2015, when the merits hearing was held, Mr. Haslage, the amount that he was paying was changed several times. It actually went from being $400, I believe, down to $200 a week, and then back up to $300 a week when we had more funds available. Sometime prior to the merits hearing in February 2015, a deal was proposed, worked out between the city of Lorain and Mr. Haslage, where they would reduce the amount that he was ordered to pay would be reduced to a civil judgment, and the city of Lorain could continue to collect on it, and he would continue paying as he always had. The trial court rejected this deal. In February 2015, the judge held a merits hearing to determine whether or not Mr. Haslage violated the terms of his probation. Mr. Haslage was current on his payment plan at that time. The judge, however, determined that the total amount would not be paid before the end of his 5-year probation period, which I believe was sometime around August of 2015. The judge, realizing this, then decided he was going to revoke his probation and order him to pay three lump sums within a very short period of time to get it all paid off before his probation was up. This appeal then followed.
Before you go on into your argument, I have some questions about the state of the record for this court. There was a magistrate's order that was issued on, I believe, March 18th of this year, and it responds to a motion to supplement the record with a number of documents, the statement of recipe, the document that didn't contain a timestamp that was entitled First Amended Statement of Evidence pursuant to 9C, trial court's order from December of 2015 approving defendant's statement of evidence. And this court permitted the statement and recipe
Your Honor, it would have all of the entries leading up to the revocation hearing. It would have journal entry. It should have the journal entries from April of 15 and February of 15, which those documents in of themselves would be, I believe, would be enough, even just those things, to show, to support our argument that the only reason that the court revoked the probation of Mr. Haslage was because he wasn't going to get finished paying in time. In fact,
But do I understand you to say that the court actually held a hearing on the probation?
yeah, there was a hearing that was held on February 25th, I believe, or February 24th, I believe the day before. It wasn't a hearing of Mr. Haslage, did not give testimony. The court had recorded it. It did not have a court reporter, but had recorded it. And when I'd asked for a copy of the court, of the hearing, they provided me a disc, and the disc was wrong. And I had to go back for a second time, and they provided me a second disc that had no sound. And when I spoke with this one from the court, I don't know exactly, the ombudsman, I guess, I'm not sure exactly his position with the court, he indicated to me that that was during a period of time when he actually had his business in Columbus and was not there to monitor things, and the volume was not turned on. You couldn't hear a thing. So there's no I have no idea the extent of, it was a very short period of time. It was, you could tell it was a very short period of time, barely 5 minutes. But you had no indication of what actually was there. And I believe that the law is clear that the trial court has an obligation to make an affirmative inquiry when they say you can't pay your fines or pay your restitution, and so we're going to revoke your probation. They have an affirmative duty to inquire. And the fact that there is no evidence that I can show that they didn't do it shouldn't penalize Mr. Haslage.
Well, but that's the whole purpose of a 9C statement. As I understand it, your argument is that the only reason why the trial court terminated probation was because it was running out of time, and that was the only way that it could ensure that these payments were made. That's the only reason. So, but if there is a hearing and there is no record of the hearing and no 9C statement where the parties come together and say, yeah, this is what the court said, this is the only
Yes,
reason why, then the appellant.
I did file a statement of facts with the record of what happened. I filed that prior to the filing of the record. That was filed with the trial court. That was provided to the opposing counsel of the state of Ohio. They received a copy of it. They didn't respond within the 10-day period. The judge then contacted me and said, what am I supposed to do with this? I said, it is my statement that was filed. That's what happened. And the judge looked at it and said, I need you to change one little word, fax it back to me and send it to the other side. So I filed that with the court. In this case, the Lorain clerks have done, to be frank, they've done a horrible job. I filed this entry, when I initially filed the appeal, they stuck it in the file and left it there for weeks. They did nothing with it, never provided it to the judge, didn't do anything with it. I had to go and open a separate case here in this court after contacting the magistrate with the Ninth District Court of Appeals. I indicated that probably would be the easiest way to do it. He also indicated I should probably file an action against the clerks. I participate there often, and that wasn't something I really wanted to do, so as a fact I didn't do it. I had filed the statement of fact, the 9C statement I had filed. The clerks didn't provide it to the judge. I had contacted the judge the day before it was due and asked him, Judge, what are you going to do with this? It's got to be sent in. The judge indicated, I have no idea what you're talking about. I never received anything. So I had to go down and prove that I had filed it, show him my timestamp copy that the court didn't even have for the original statement. That's when he asked me to do the subsequent statements.
I understand. Okay, go ahead with your argument.
Sure. As I've said, the case law is very clear. United States versus Taylor, the Supreme Court, United States Supreme Court case, it is almost identical to this case. Man was convicted, Taylor was convicted of tax offenses where he didn't pay his income taxes. He was sentenced to fines. He wasn't able to pay them in time. The court revoked his probation. The Supreme Court said that non-payment of fines with no other issues which would violate the defendant's probation, would not subject him to imprisonment. Same thing here. Mr. Haslage was in a payment plan, was making regular payments, was current on his payments. Suddenly the judge realized he wasn't going to be all paid in time, and he pulled the rug out from under him and said, you're not going to get it paid in time, so now we're changing the terms of your deal, and you got to get it all paid within a very short window. Bearden versus Georgia, the Supreme Court, similar circumstances, placed the onus on the state or on the trial court to actually inquire. They said in revocation proceedings for failure to pay a fine or restitution, a sentencing court must inquire into the reasons for the failure to pay. Ohio has adopted this idea in multiple cases, including State versus Richardson, which reversed when the trial court did not inquire into the reasons for not paying child support. His record didn't reflect that any inquiries made into Mr. Haslage's ability to pay. No recording exists, as I indicated. We kind of went over that already. Mr. Haslage should not have to prove that the inquiry was not made. The judge, there should be something in the record. The judge should put something in his entry indicating that there was a reason, that the reason for his non-payment, or revocation, excuse me. So Mr. Haslage has made bona fide efforts to pay. He's paid over $27,000 out of $67,000 total that was due and owing. He maintained a dialogue with the city of Lorain to try to work out a deal with them to reduce it to judgment, to continue paying on it. Every time he's had fluctuations in income, he's gone to the city and worked out a new deal where he could adjust what he was paying based upon what he had. The appellee's only argument in their brief is that there's no indication that the only reason they revoked his probation was because of money and his ability to pay. However, that's just nonsensical. The only thing he's ever been accused of is not paying his fines. He never had any other issues.
Is there a distinction between fines and back taxes?
I don't believe so, Your Honor. Whether it's paying restitution or back taxes or any other penalty imposed by the court, if you have an ability, the question is whether or not you have an ability to pay it. And I believe the court has an affirmative duty to inquire to find out whether or not he had that ability to pay it. And the court didn't do that. And even if it had, you would see he was current. He was making bona fide efforts to make payments.
So during the years that he was operating his business and he was receiving income from his contracts with his clients, and they were paying him, there was no money to pay the taxes at that time.
That's my understanding from his financial difficulty. He filed bankruptcy in 2005, so I know he was having some sort of financial problems. And the amounts that were due was sometime between about 2003 and 2008, so it's right in that period of time where he was having a great deal of financial difficulty. In fact, he had one company initially which he had to shut down, and he opened up a second business, and I think he actually had 2 or 3 different businesses trying to get work at the same time in conjunction with the original business. And it was just a matter of he was robbing Peter to pay Paul, and unfortunately the city was the one who he didn't pay the taxes to. They're not arguing that. I mean, he pled no contest to that, and that's why he's paying the money back. The issue is whether or not he had the ability to pay these lump sums, and whether the court could essentially pull the rug out from under him and change the terms of the deal without any reason for it when he was actually making the payments.
And you've reached the end of your
We would ask the court would vacate the trial court's judgment. Thank you, Your Honor.
You're welcome.